Mr. Hobbs, do you want to provide any clarifying remarks before we begin?
Yes, Mayor, thank you. So let me just kind of focus the council on the legal issue that you're being asked to decide. Under SB 35, as you've heard from our staff, the standard is whether or not the project complies with the city's objective standards. And there seems to be no dispute that it doesn't, because the project proposes to put residential uses on the residential uses on the ground floor, which conflicts with the Old Town SBA, which leads to the request by the applicant for a waiver of a development standard. And you've heard from the applicant's attorney why they feel that the waiver of the development standard is proper. I respectfully disagree with that approach. When you look at the statute that governs the development standard waiver, it includes matters such as site and construction conditions. And then it includes the phrase that you've heard from the applicant's attorney, including but not limited to, which is fairly typical language you'll see in statutes. But the problem with lumping in the land use provisions under that statute is when you look at the types of standards that can be waived, it has matters such as height restrictions, setback restrictions, floor area restrictions. And it's a basic tenet of statutory construction that when you look at specific terms in the statute and determine whether or not the general terms apply as well, you read the general terms as limited by the specific terms. And it's a Latin phrase that essentially means of the same kind. There's a Latin term for that under the law. And so when you have general language such as including but not limited to, and then a number of specific items, the including but not limited to has to be considered in terms of the types of limited specific items. And the reason this is important in terms of land use is because cities, general law cities such as Elk Grove, have historic and constitutionally endowed land use powers. It's right in the Constitution, the police powers, a very strongly supported provision of state constitutional law that cities have land use authority. The legislature has declared by statute, Government Code Section 65800, that its intent is to minimally regulate local zoning to the extent necessary or proper in the eyes of the legislature. And with the city's police powers, the historic and constitutional police powers, which are found in California Constitution, Article 11, Section 7, and as embodied by a number of cases, one Supreme Court case of note is Big Creek Lumber versus County of Santa Cruz. It's a 2006 case. The site is 38 Cal 4th, 1139. And that, among other cases, illustrates the principle of the broad constitutional land use authority of cities. Now, the legislature can preempt that. They have the authority to preempt that. But when they do that, they need to speak with clarity and precision as to what's being preempted. And when I read the definition of development standards here, I don't see that it would preempt land use authority, your residential, your commercial. Now, perhaps it can deal with things like setbacks, height restrictions, but that's not what's being requested here. What is being requested is a deviation from the fundamental land use authority, the zoning of the city. And I don't read the development standard to apply, the definition of development standard to apply here to provide for that waiver. So as a matter of statutory construction and state law, it's just not available. Now, we heard tonight that there was a suggestion that the relief from the zoning code provisions could be provided under a different section of the statute. It's Government Code 65915D, as in dog 1. That statute, as explained in your staff report, deals with a different provision called concessions and incentives. What that provision says is that you can be relieved as an applicant from certain land use provisions under as a concession or incentive, but if you ask for that, the city is entitled to ask for your cost savings to determine whether or not it's appropriate, whether or not there's cost savings as a result of this. And staff, frankly, misunderstood that to be the request of the applicant early on. And then later in late May, I received an email from the applicant's attorney telling me that the city is misunderstanding the request. The applicant is not seeking a concession or incentive. Rather, they are seeking a waiver. And so the city staff, myself included, went down that path and analyzed this as a waiver. So the applicant has abandoned this notion of a concession or incentive. It's just not just not something that they're asking for. And you'll see that also in their letter of July 13th, where they make it clear that they are not asking for an incentive or concession because they didn't want to provide us cost analyses. But that very letter also indicates that there will be a cost savings of not having residential on the ground floor of about $2 million. Now, to be fair, the letter goes on to say, but if we don't put residential on the ground floor, the feasibility of the project doesn't work because we won't be able to manage the project in a financially feasible way. But the problem with that approach is the courts have said that cost savings for the construction and project feasibility are two different things. And so when we look at cost savings with respect to, in the context of, say, a concession or an incentive, we look to see whether or not there will be construction savings. So there's evidence in the record that there actually will not be construction savings, cost savings, if the concession is granted. But none of that matters because the applicant is not requesting a concession. They've abandoned that approach. So it brings us back full circle to the notion of a development standard waiver. And for the reasons that I've just explained, under state law, it simply does not authorize the waiver of fundamental land use, your residential or commercial. Now, you've heard from the applicant that, well, that's not really land use. That is a development standard because it's saying where your types of use are going to be. And that's right. It is saying where the types of use are going to be. Residential needs to be on the second and third floor. That's part of your zoning code. Commercial needs to be on the ground floor. That's part of your zoning code. You've also heard from the applicant's representative about how there was another project, a market rate project that was approved that had commercial on the ground floor for the front-facing units, and there was some residential in the back that didn't necessarily have that. However, those are really apples and oranges when you look at the types of different projects. That project was a traditional design review project where the Planning Commission is authorized and the City Council, if it gets to you, has discretion. Now, if this applicant wants to apply through a traditional land use process, that's fine. They could do that. They would be subject to CEQA. The Planning Commission would have more discretion over the design, the location. There's a lot more latitude. This applicant has chosen to follow the SB 35 process. So that brings it to your charge to strictly look at the objective standards. It applies equally to us, to them. I think I heard tonight that the applicant's representative says that this project meets the, I wrote it down, the intent and spirit of the SPA. Well, the intent and spirit is not what we're looking at when we look at objective standards. It does it comply or doesn't it? And I think everyone, including the applicant, would acknowledge this does not meet the objective standards for the ground floor commercial. So the only way ground floor commercial, the only way you get to an approval is if you grant the waiver. And for the reasons I've said, it just isn't eligible and available under state law. And so staff's recommendation remains to deny the project simply because it doesn't comply with the objective standards and the waiver is not available for this project. Happy to answer any further questions for you.